but frankly, I want to cover so much today, and many of you have heard some or all of my journey that has brought me here. In a reflection or elsewhere, I may cover that on another day. This Mueller report, I think, is one of the most important documents in the history of the American presidency. I don't think it's getting the accurate attention it deserves. If anyone told you that a little over 2 years into their presidency, a 448-page report would come out documenting the sitting president of the United States' involvement with the Russians in undermining the 2016 election and then obstructing justice to conceal and disrupt the investigation of that involvement, one can't imagine a Barack Obama surviving such a thing, or even, I dare say, a George Bush or a Bill Clinton. But we are in a new normal, a tragic new normal. A president who lies 10,000 times, according to the Washington Post, which has a guy that tracks and documents every lie every day by the President of the United States. He has inured much of the American public and elected officials to his despicable conduct. And the importance of the Mueller report is the documentation of much of this. And I have some criticisms of the Mueller report, which I'll try to outline today. But by and large, Robert Mueller did his job. And the question now is whether Congress and the American people are going to do their job. I'm indebted to the Los Angeles Review of Books, which commissioned me to do a 6,000-word review of the Mueller report. I was able to dig into it immediately, stayed up till 3:30 in the morning, right on the eve of doing this publication. It was in the context of a book review because there were two instant books that came out. The Mueller Report, with commentary by reporters from the Washington Post, came out within days of the report, and a second publication, the Mueller Report, with an introduction by Alan Dershowitz. I'm going to dwell a few minutes on my criticism of Alan Dershowitz's introduction, which I think is shameful and only adds to perpetuating the cover-up and the apologies for President Trump. I also did a radio interview on Wednesday with Jim Lafferty at KPFK, which is online, and you can see that. And this talk is being live streamed and will be available on the ICUJP website as well. This was an exhaustive report, 448 pages, 2,381 footnotes, following an exhaustive 22-month investigation. Robert Mueller and his team chose to divide the report into two volumes. Volume 1 focused on Russian interference and the question under criminal law of whether Donald Trump conspired with the Russians, which I will talk about in a moment. Volume 2 of the report focused on obstruction of justice. I believe Robert Mueller made a mistake in so sharply separating the question of conspiracy with Russia from the question of obstruction of justice. I think these two issues are far more interrelated, not only in a factual and thematic sense, but in a very serious legal sense, which I'm surprised Mueller overlooked. If I leave no other impression, it is that the Mueller report is only one part, a very important part, but one part of the investigation of Donald Trump and holding him accountable. There are multiple investigations pending. There are 14 pending criminal investigations, one of which will be a trial of Roger Stone, one of Trump's insiders, and there are 11 potential prosecutions under criminal law. Many of these are pending in the Southern District of New York, which is an independent federal jurisdiction, and many of, beyond what I've just said, are state prosecutions in New York and elsewhere. I will later come to the question of whether you can prosecute a sitting president under federal law, but there is no prohibition on prosecuting a sitting president under state law, and all of that remains to be seen if those state prosecutions go forward. Mueller was conducting a criminal investigation. When you look into whether someone committed a crime, there's a very high bar. And as a civil libertarian, I want that bar high for prosecuting crimes. Often, local, state, and federal prosecutors are far too aggressive in their prosecutions in the criminal area. So I would give no brook to anyone in expecting the government to meet the high standards for criminal prosecution. Under federal law, conspiracy, and the term is conspiracy in federal law, not collusion. There is no criminal term for collusion. For the president to crow that there was no collusion misses the point. The question was his involvement and the question in the Mueller report of whether or not he committed a crime. Conspiracy requires a knowing and intentional agreement between at least two parties and one or more overt steps in furtherance of that conspiracy. Russian spies are not in the habit of leaving behind evidence of their agreements with witting and unwitting helpers. Mueller found that he could not satisfy the high standard of proving beyond a reasonable doubt, the highest standard in our law, higher than in civil cases, if he was to go forward with respect to proving a criminal conspiracy between Trump and Russia. Now, minds can differ on this. The Mueller report documented 100 in-person meetings, phone calls, text messages, emails, and private messages between more than 24 Russian nationals, WikiLeaks, and intermediaries on the one side, and Donald J. Trump and 18 of his election campaign officials and advisors, including Donald Trump Jr., Ivanka Trump, Jared Kushner, Paul Manafort, Michael Cohen, Jeff Sessions, Michael Flynn, Carter Page, and Roger Stone. Trump engaged in at least 10 of those direct contacts with Russian agents and operatives, although on the eve of the election, Trump promised the American people he had nothing to do with Russia. The report confirms that the investigation established that the Russian government perceived it would benefit from a Trump presidency and worked to secure that outcome, and that the campaign expected it would benefit electorally from the information stolen and released through Russian efforts. The public service of the Mueller Report in Volume 1 is a detailed documentation of Russian interference. It is the most public, detailed, comprehensive report we yet have on actual Russian interference. No one, no sentient human being can ever again doubt the actual interference by Russia in the 2016 election. But Mueller's conclusion that Trump is not criminally culpable of the charge of conspiring with the Russians does not end the matter. I've told you about the other pending prosecutions. A sitting president can still be indicted after leaving office.
Okay, I found this on the web. A sitting president can still be indicted after leaving office.
Wow.
Check it out.
Wow. Your
My
phone is talking.
my own
to you.
interference.
watching.
Steve,
Steve, can I just
Yes.
quickly, something's been bugging me and I hope we can kind of get this dealt with. Since when does the person on the investigative or even prosecuting side need absolute evidence of guilt? Isn't that to be decided by the court?
The test that Mueller expressed, and he went into this particularly in Volume 2, the prosecutor must have a reasonable belief that at the end of the day, a jury could convict beyond a reasonable doubt. That's one of our constitutional protections. And in many ways, Mueller is such a contrast to Trump. Mueller bent over backwards. I'll get in a moment to the kind of ethical approach that Mueller took toward Trump, even as Trump was attacking Mueller. So let me turn to Volume 2 on obstruction of justice, because this remains the most fertile area for future accountability. But, and I haven't mentioned the name William Barr yet, Donald Trump got the Attorney General he was yearning for since the day he took office in William Barr. William Barr is the Attorney General Trump wanted instead of Jeff Sessions. William Barr has lied to the American people. William Barr has lied to Congress. William Barr distorted the Mueller report in Barr's short letters to Congress that Robert Mueller took the extraordinary step to write a letter to Congress saying that the content, meaning, and interpretation of his report had been distorted by William Barr. That effort to seal the public mind on the eve of the full release of the Mueller Report by William Barr, I believe separately is a grounds for the impeachment of William Barr, if we ever got there. One of the big distortions was for William Barr to facilitate Trump's ability to say, no collusion, no obstruction of justice. On obstruction of justice, that is not what Robert Mueller found. Mueller introduced Volume 2 with 4 very serious considerations. And I'm going to allude to them in some detail because they've been completely or largely overlooked by commentators and certainly by the apologists for President Trump. His first consideration on how he approached obstruction of justice was as follows. First, a traditional prosecution or declination decision, declining to prosecute, entails a binary determination to initiate or decline a prosecution. But we determine not to make a traditional prosecutorial judgment. The Office of Legal Counsel, which is a wing of the Justice Department, has issued an opinion finding that, quote, the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions in violation of the constitutional separation of powers. Consequently, special counsel accepted the OLC legal conclusion for purposes of exercising prosecutorial jurisdiction. What that means is that because there is simply a memo in the file at the Office of Legal Counsel, no court has ever said this. The Constitution does not say that a sitting president cannot be prosecuted while in office, and no court has ever so held. An opinion of the Office of Legal Counsel says that, and as a good soldier, Mueller accepted that policy. So he knew he could not indict the president because of that reason. Barr, Dershowitz, and others have tried to obfuscate that point. The second consideration Mueller made was that while a sitting president may not be prosecuted, a criminal investigation during a president's term is permissible because, according to that same OLC memo, recognizing an immunity from prosecution for a sitting president would not preclude such prosecution once the president's term is over or he is otherwise removed from office by resignation or impeachment, unquote. The Mueller Report raises the prospect of impeachment in its own terms. This is the signal I believe Robert Mueller was sending to Congress and to the American people. He said that we conducted a thorough factual investigation in order to preserve the evidence when memories are fresh and documentary materials were available. In the same breath, Mueller specifically refers to impeachment and his intention to preserve the evidence. The third Mueller consideration was he decided not to apply an approach that could potentially result in a judgment that President Trump committed crimes because fairness concerns counseled against potentially reaching that judgment when no charges can be brought. This would preclude a speedy and public trial and an adversarial opportunity for public name clearing before an impartial adjudicator. This is an extraordinary level of ethical attention to his job. He showed admirable fairness toward Trump, who should be ashamed of himself for his baseless attacks on Mueller before the report was issued. And the fourth consideration produced maybe the most quoted sentence in the entire report, and I quote it in full. If we had confidence after a thorough investigation of the facts that the president clearly...
Steve, somebody's phone keeps going off and it's very distracting.
Could we turn that on?
Ruby, could you turn your phone off?
I don't have my phone on.
It's making a sound.
No, this isn't making a sound.
Oh, then someone says.
All right, let me continue. We're on
Sorry, Steve.
live video stream. Here's what the Mueller report said. If we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment. The evidence we obtained about the president's actions and intent presents difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while this report does not conclude that the president committed a crime, it does not exonerate him. That was as careful a threading of the needle by a fair and ethical prosecutor one could imagine. Nowhere does Mueller say he was leaving it to the Attorney General, William Barr, to decide whether or not to indict Trump for obstruction of justice. Volume 2 proceeds in 128 pages to document in detail, based on extensive sworn testimony by first-hand witnesses and contemporary documentation, a shocking, in my words, pattern of presidential abuse of power. These pages reek of corruption and villainy. They portray a president unbound by the fundamental standards of morality, which ordinarily constrain decent, law-abiding people, let alone one who has accepted the mantle of President of the United States and has expressly sworn to take care the laws are faithfully executed and, quote, preserve, defend, and protect the Constitution. The report describes at least 10, and how you count these varies, it could be more, occasions on which President Trump attempted to interfere with and obstruct the investigation and cover up activities that he may have believed were politically and legally damaging or harmful to his election, including demanding personal loyalty from government officials, asking that criminal charges against Michael Flynn be dropped, firing the director of the FBI during the pendency of his investigation into the Trump campaign, and later saying he did it because Russia was on his mind, misrepresenting to the American people why he fired the FBI director, asking intelligence officers to clear him of any wrongdoing, trying to limit the scope of the investigation into Russia and his campaign, asking Attorney General Jeff Sessions to unrecuse himself and go ahead and investigate Hillary Clinton, threatening to fire Sessions, dictating a misleading statement about the key meeting at the Trump Tower between Russians and members of his campaign, ordering his legal counsel to fire Mueller, and when that lawyer refused, demanding that counsel fabricate a report denying the original presidential order, telling Manafort, Flynn, and Cohen to stay strong while they were under indictment, and promising through his lawyers they would be taken care of unless they went rogue, and threatening Michael Cohen by suggesting that his father-in-law might be at risk. Think of that just brief summary of the repeated, deliberate, and intentional acts of obstruction of justice. Now, the point that I believe Mueller and a team of over 20 lawyers overlooked, if I may so humbly suggest, is a very important doctrine in criminal law called consciousness of guilt. Consciousness of guilt is an ancient doctrine borrowed from English law, written into American law, most prominently in a 1923 treatise, Wigmore Treatise on Evidence. And it's a very simple, fundamental point that we experience in our daily lives. As Wigmore says, quote, "A criminal act leaves usually on the mind a deep trace in the shape of a consciousness of guilt. And from this consciousness of guilt, we may argue to the doing of the deed by the bearer of the trace." The Supreme Court upheld the doctrine in 1896. Quote, "If a man does an act which he is conscious is wrong, he will pursue a certain course not in harmony with the conduct of a man who is conscious that he has done an act which is innocent, right, and proper. The truth is, and it is an old scriptural adage, that the wicked flee when no man pursueth, but the righteous are as bold as a lion. Men who are conscious of right have nothing to fear." Consciousness of guilt is in our law. In California, in criminal trials, judges routinely read instructions to the jury to give them guidance on the law. And these are judicially approved instructions. In this case, they will tell a jury that if you find the defendant made a false or misleading statement before this trial relating to the charged crime, knowing the statement was false or intending to mislead, or tried to hide evidence or discourage someone from testifying against him, that conduct may show he was aware of his guilt of the crime, and you may consider it in determining his guilt. Of course, most accused criminals are not also the head of the executive branch of the United States government with the ostensible power to shut down an investigation into their own conduct. But under the well-established legal doctrine of consciousness of guilt, Mueller should have considered the substantial evidence of consciousness of guilt, which he found in Volume 2, should have been included in judging guilt in Volume 1. I have seen no other commentator, no other lawyer, no other analysis now a month later after the Mueller report that has made this point. So I was proud to go public with it in my book review immediately after the report came out. These two commentaries came out. I won't spend much time on the Washington Post. This is a journeyman case of briefly describing the report, written within days that it came out. I'm a little disappointed in the Washington Post. They didn't do a more intensive review of the report. Much of their reporting appears to have been written before the report was published in anticipation of what it might say. You should know that most newspapers write obituaries before famous people die. But the introduction by Alan Dershowitz deserves some attention. For some reason, Alan Dershowitz, in his introduction, was very defensive about his purported impartiality. In his introduction, which is only 12 pages long, he discloses he voted for Hillary Clinton in 2016 and for Democrats in the 2018 midterms. And that as a civil libertarian who cares deeply about the fair application of the rule of law to all, he promises to, quote, apply neutral, nonpartisan principles to his analysis. Now, a month ago, as if he had some inside information, he promised his readers that a formal written response by the Trump legal team to the Mueller report would be forthcoming. No such response has ever been published to this date. But what I was most shocked initially is claiming that fair-minded citizens should withhold final judgment until they have read both the report and the White House response, which has never come, except in tweets. Dershowitz, in his introduction, fails to tell his readers that in July of 2018, he published a full-length book entitled The Case Against Impeaching Trump, and made scores of television appearances defending Trump. And in 2018, he argued that even colluding with the Russians would not be a crime. It's troubling because anyone coming to this fresh should know that Dershowitz is no independent-minded, Democrat-voting legal analyst. It's remarkable that in his brief 12-page introduction, Dershowitz spends 4 pages analyzing the report. Much of the rest is a relitigation of the Hillary Clinton investigation and also of Dershowitz's pet suggestion 2 years ago that there should not be a Mueller investigation at all, that a toothless commission should have been appointed, to look into the matter. When he finally does get to the report on page 9 of his 12-page introduction, Dershowitz makes some fundamentally flawed legal arguments. Along with Trump's lawyers, Dershowitz claims that so long as a president is acting pursuant to his authority under Article 2 of the Constitution, he cannot be guilty of obstruction of justice. The only example he uses to elaborate on this is the firing of James Comey. His position is, and I agree with the first part of what I'm about to say, that a president of the United States, as the head of the executive department, can hire and fire the director of the FBI. The problem is he cannot do so for a corrupt or illegal purpose. The President of the United States has the absolute power of pardoning federal persons who committed a crime. The President of the United States cannot accept a bribe to grant a pardon. Absolute power to grant pardons cannot do so for a corrupt purpose. Now, Dershowitz accuses the Mueller report of being entirely one-sided on this issue. And what Dershowitz overlooks is a 26-page section of the Mueller report headed Legal Defenses to the Application of Obstruction of Justice Statutes to the President, in which Mueller takes up the President's lawyers' arguments and conclusively answers each one of them in the report. Dershowitz ignores all of that. Dershowitz claims that Mueller interpreted constitutional law incorrectly, and he declares that the federal court decisions cited by Mueller were all wrongly decided in my view. That's his answer, that federal court decisions Mueller relied on were wrong. I wish I could have successfully argued like that in court. Dershowitz doesn't cite a single court decision, treatise, or law review article to support his position. On the other hand, Mueller cites 2 federal appellate decisions for the proposition that, quote, an improper motive can render an actor's conduct criminal even when the conduct would otherwise be lawful or within the actor's authority. One of the cases cited by Mueller for that proposition was a case in which Alan Dershowitz was on the losing side of the case, none of which he discloses to his readers. And that is in which a jury was instructed under federal law that any act by any party, whether lawful or unlawful on its face, may violate obstruction of justice if performed for a corrupt motive. The intent may make an otherwise innocent criminal act into a step in the plot. So it's very clear to me that the firing of Comey for corrupt purposes was an act of obstruction of justice, and that the president, as Mueller said, had no more right than other citizens to impede official proceedings by corruptly influencing witness testimony. Dershowitz can't quite hold on to that outlandish position. He finally, in the closing moments of his introduction, says, "Does this mean a president can never be charged with obstruction of justice? Of course not. President Nixon could properly have been charged with obstruction of justice because he went well beyond his constitutional authority by telling his subordinates to lie to the FBI." In my book review, the next word is really? Is Dershowitz so oblivious of the connection between those acts committed by Nixon and the acts which Trump is accused of? That litany of obstruction of justice, we could have switched the names to Nixon. Which brings me to the final portion of my talk today, which is inspired by the work of Elizabeth Holtzman, The Case for Impeaching Trump, written before the Mueller Report came out. Some of you, when I look around the average age around this circle, remember Elizabeth Holtzman, youngest congresswoman elected to Congress from New York and appointed to the House Judiciary Committee, who sat in the Nixon impeachment. A woman who has a lot to say with a lot of good authority. In 1974, the House of Representatives was in the control of the Democrats. But the Senate, while in control of the Democrats, did not have 2/3 majority vote in the hands of the Democrats, which is the percentage required for the Senate to convict a president and remove him or her from office. Let me say that more specifically. Under the Constitution, the House of Representatives indicts a president on impeachment by issuing articles of impeachment by a majority vote of the House of Representatives. That is an indictment. That goes over to the Senate, which sits as a jury and must vote by 2/3 of the Senate to convict and remove the president from office. That is how the founders, they were very serious to offer the Constitution and the American people a remedy against an officer, including the President of the United States, who committed political abuses of power. But they were a bunch of smart, though slave-owning men. And on this side of the ledger, they wrote a constitution that would not leave the American people with periodic elections to deal with abuse of power. They put the power and authority and responsibility of impeachment in the Constitution in the way that I've described. My point coming to 1974 and reflecting on the agonizing today that Nancy Pelosi and others are going through is that there was no guarantee Nixon would be convicted and removed from office because there was no 2/3 Democratic supermajority in the Senate at that time. What it took was displaying the evidence before the American people, having hearings with live testimony, not the dusty 448 pages that a fraction of a percentage of the American people have yet to read. But to put that evidence before the American people, because that's what happened during the Nixon impeachment. The American people saw the evidence of corruption and obstruction of justice before their eyes. Public opinion swung in support of impeachment, and Republicans walked across the street and told Richard Nixon he had to resign. The challenge today is whether, by and large, the Democratic Party and Republicans of conscience have the courage to do the very same thing at this moment in American history. To display that evidence before the American people. To accept the responsibility that the Constitution offers this remedy. We are not in a constitutional crisis. We are in a crisis of conscience and courage. The Constitution gives us all we need right now. There is no constitutional crisis. The crisis is for Congress to use the powers they have at hand.
But are the Republicans of conscience?
They have begun to rouse themselves. They are using investigative powers and subpoenas to pursue this president, but they need to name it as impeachment, because no court will deny them tax returns and financial information if they are pursuing impeachment, because then all of the president's conduct is at stake. Last Monday, in a 41-page opinion, a very serious federal judge upheld a subpoena to Donald Trump's accounting firm, saying there were at least 4 legislative purposes for that subpoena. And I believe that that was the right decision. And that case will be appealed. And we're going to have to watch what happens when it gets to the United States Supreme Court. What will Gorsuch do? What will Kavanaugh do? And perhaps most importantly, what will John Roberts do? If John Roberts is building a legacy, can he look at the law in that 41-page opinion, which came out Monday, that says you don't second-guess Congress when it states a legislative purpose to investigate the executive branch? You uphold the oversight responsibility of Congress when it comes to its duty. That law was irrefutable. And the judge chided the lawyers for Trump because they couldn't come up with a case newer than 1880, when all of the law of the United States Supreme Court has developed in that regard. Elizabeth Warren has laid out the blueprint for impeachment of Trump. She has articles of impeachment in her book, and she is not alone. Representatives Brad Sherman, Al Green, Steve Cohen, Luis Gutierrez, Adriana Esplinat, Marcia Fudge, and John Yarmouth have all introduced articles of impeachment in the House of Representatives. It is all there for them to see. what Elizabeth Holtzman has done in a breakthrough analysis, the first time I ever saw this, she has an article of impeachment as follows: failure to protect the integrity of our federal election process. She has given the insight that put aside Trump's criminal conduct in conspiring with the Russians when it was clear the Russians were interfering in the 2016 election. Donald Trump didn't lift a finger to call the Russians on that. He did the opposite. And Elizabeth Holtzman has a series of indictments that Trump disregarded his responsibilities as commander-in-chief to repel and prevent attacks on our country, including cyber attacks, impaired the basic constitutional right of Americans to fair and honest elections, systematically made false and misleading public statements for the purpose of deceiving the American people about the identity of the attackers and his knowledge, and withheld relevant material evidence, information, and assistance from the intelligence community, which was trying to block the Russian attacks. As a result, President Donald Trump's refusal to act endangers the people's right to free elections, a foundation of our democracy. It is a great and dangerous offense. It subverts the Constitution. Impeachment is the remedy our Constitution provides for such misdeeds. Others have called for impeachment. Lawrence Tribe, prominent constitutional law professor at Harvard, Yoni Applebaum, senior editor of Atlantic, had a front page cover story documenting the grounds for impeachment. Journalist Elizabeth Drew, who covered the Nixon administration, and many others. And public opinion is moving in that direction if public opinion would be supported by the Democratic leadership. As I conclude, to hopefully leave a little bit of time for questions, this doesn't mean that the Democrats can't walk and chew gum at the same time. The Democrats need to advance a progressive agenda for the American people. They need to be doing it now. If the president shuts the door on infrastructure, pass an infrastructure bill in the House of Representatives. Send it to the Senate. Let them stand and be judged by whether they will support roads and bridges and infrastructure for the American people, and whether Donald Trump would veto it. And when they go to the American people in 2020, they've got to know that they need to convince Americans that they care about supporting working families, affordable health care, full employment and a living wage, racial justice, criminal justice reform, the appointment of judges who uphold civil liberties and civil rights, a more equitable tax system, protecting Social Security, affordable housing, protection for women, the disabled, and LGBTQ rights, public education from kindergarten to college, humane immigration and asylum policies, protections for the environment, gun safety, veterans' rights, and a humanitarian foreign policy to end endless wars, protect human rights, and eliminate war profiteering. The Democrats need to go to the American people with that agenda today and every day for the rest of this term. They need to live up to their responsibilities to impeach this president. And if that Senate, in control of the Republicans, blinks and fails to live up up to its constitutional responsibilities. And if that Republican Senate gives Trump a pass, then shame on them as we enter the 2020 election, and hold them accountable and the president accountable. And if we need to remove him from office in the electoral forum, then let's remove him and that Republican-controlled Senate. That's what the Constitution requires. That's what democracy requires. And I believe every one of us has a fundamental role to play in that. Thank you very much.